can I thank everybody for attending this seminar. As family lawyers, we have an enormous amount of reading to do. And after you've read the many papers in a bundle, the idea that you should then have to descend into reading pages and pages of case law in order to identify the relevant points of law in a case is something that causes me, and I'm sure many others, to be tired and despondent. So what we've done is to prepare a table for you, setting out the reported decisions over the past 12 months in the public law arena. That table has been sent out to everyone, so we hope you've got it. It's going to be put up on the screen in a moment. If you're in a hurry and you want to find a case and you think there's been a case on this and I can't remember what it is, you'll see there's a middle column in the table, and that gives you the headline. So, for instance, if you suddenly think that there's been a case about whether to hold a fact-finding hearing, you'd look at the middle column. You'd be able to find it very quickly. On the left-hand side, you would then see the case, and on the right-hand side, hopefully cutting out too much blather, you would then see the essential things that you need to know. We thought it would be more helpful to put the cases into that table rather than into a set of PowerPoints. I don't know about you, but I get rather fed up of going to conferences where I experience death by PowerPoint anyway. But the problem with PowerPoints is that it's not so easy to find things as hopefully will be the case with this table. Thank you very much to LexisNexis for organising this. Today, we're going to look at three headings: fact-finding hearings, practice and procedure that Mark Calway is going to cover, and care and placement orders and the recent authorities that have been released in relation to that. Hopefully Jane Withington will be joining us. She's stuck in court at the moment. If she can't join us, then I will do her piece. But it will be covering cases 1 to 26 today. We may not cover it all because there is another conference, as you all know, on the 19th of June, when we will cover the balance of this handout. If you've got questions, do feel free to put them in the Q&A. We will try to pick up on those as we go along, but our focus is going to be pretty much on what we are delivering today. There may not be that much time to spend on Q&As. If we get a question and we think it needs to be covered, we can release it to you, an answer to you later by email if you would like us to, or else we could cover it on the next occasion. So here goes. Let's look at the table, please. I'm going to start, surprisingly, with the first case on that. And this relates to whether to hold a fact-finding hearing. Now, some of you will know that there was a decision of Mrs. Justice Leven. I've called it the Derbyshire case in this handout, and the reference you'll see on the table. And following that case, certainly I've heard quite a few advocates seeking to suggest that that case creates new authority about when a fact-finding hearing should be held. And the importance of the first case on this table is that it rejects that suggestion. The case, the Derbyshire case, was no more than an example at first instance of a judge deciding not to hold a fact-finding hearing. And it's important to apply principle rather than trying to apply analogy. And what the Court of Appeal said in the case that we're dealing with, Re P and E, is that the law is as stated in the Court of Appeal decision that I've set out here, re HDH. And what that does, and you have to look at re HDH in paragraphs 15 and 16, because it refers to early authority and says that the authorities make it plain that amongst other factors, the following are likely to be relevant and need to be borne in mind before deciding whether or not to conduct a particular fact-finding exercise. And it then lists A to I, the interests of the child, the time that the investigation will take, the likely cost to public funds, the evidential result, the necessity or otherwise of the investigation, the relevance of the potential result of the investigation to the future care plans for the child, the impact of any fact-finding process upon the other parties, the prospects of a fair trial on the issue, and the justice of the case. That is not an exhaustive list. And of course, where you get arguments about whether to hold a fact-finding hearing, it's important to remember the rules, in particular, the overriding objective in Part 1 of the Family Procedure Rules 2010. So if you get or involved in an argument as to whether to hold a fact-finding, could I encourage you, please, not to cite the Derbyshire case as if it were authority. It isn't, and it's qualified by the decision that we are discussing. Could I suggest, please, that you look at paragraph 16 of re HDH, which contains the passage that I've just been reading to you, and that you apply the principles that are expressed in that paragraph, also referring to the overriding objective. I think also in this day and age where an awful lot of cases do get reported at first instance, it is important to recollect that there is precedent within the court system, and a decision of the Court of Appeal takes precedence over a decision of a judge at first instance, including, of course, a High Court judge. So it's a tale of caution, I think, within this case. I'm going to move on to the second case, which deals with that complicated issue about a pool of perpetrators. What this case does, amongst other things, follows from what I've said about the first case, and that is it reminds people to apply principle. There are principles within family law, within public law, and it's for us as lawyers to apply them. So here, the court robustly restated the disciplined approach that was expressed by Lord Justice Peter Jackson in the case that you can see on your screens or in the table. The passage that is cut and pasted into the table sets out how a court should approach a case where there is a potential pool of perpetrators. Identify a list of people, consider whether the local authority has proved on the balance of probabilities that a person was the perpetrator. If not, identify those persons on the list who are of whom there is a real possibility that they were the perpetrator. And there, in this case, the court, I'm afraid, went wrong and the appeal was allowed and the whole thing had to be reheard. These issues are of such importance. Personally, I think that fact-finding hearings are some of the most difficult hearings that we do, and the burden on the judge of getting it right is huge. If a judge finds, for instance, that a father caused the injury, whereas in fact it was the mother, then that not only amounts to a grave injustice for the parents concerned, it has a very material impact on the welfare of the child. And perhaps most importantly of all, it could expose the child to considerable danger, because it could lead to the child being rehabilitated to the very person who had in fact suffered the injuries. That is why in this area of law that we are discussing, the suggestion that one should strain the evidence to find a perpetrator has to be approached with real caution, because if you go too far in your quest to identify a perpetrator, you could be getting the case horribly wrong and leaving a child in considerable danger. And I'm afraid there are examples that I've seen where just that has happened. The third case is about whether a parent can be expected to provide an explanation for events that have occurred, and where is a judge entitled to take into account the absence of an explanation when deciding who had caused the injuries. And the argument was that in this case, where the judge said the parents didn't come out with an explanation, and it would have been, one would have expected them to be able to do so, and therefore I am taking that into account. The argument was that the judge wasn't entitled to do that, and that amounted to reversing the burden of proof. Now, how many times have I heard that argued in court, where it said, well, the local authority says the parents haven't come out with an explanation, it's not for them to do so, the burden's on the local authority, and you can't do anything about the absence of an explanation, even though in these circumstances the parents might be expected to provide one. Well, this decision qualifies that line of argument. And what happened was that as to that argument, Lord Justice Peter Jackson said that argument, that the judge reversed the burden of proof in respect to the father by noting the lack of an account of an accident by the parent, is a familiar argument addressed in another case called BR. It would, of course, be wrong to apply a hard and fast rule that the care of a young child who suffers an injury must invariably be able to explain when and how it happened if they're not found to be responsible for it. However, the absence of any history of a memorable event where such a history might be expected in the individual case may be very significant. I'd suggest actually that's quite obvious, and it's merely to express common sense. One of the other points that I'd like to mention when discussing this case relates to what's called circumstantial evidence. I think when approaching evidence, we do have to keep our lawyers' hats on, and when we are analysing evidence, it's helpful to categorise the evidence that we are dealing with. So, what is circumstantial evidence? Let me give you this example. You come out of a room using the only door into the room. When you leave, there is only one other person in the room, your, let's say, client. Someone else goes into the room and then leaves it. No one else goes in. When you next go into the room, your client has a knife in his or her back and is dead. Now, circumstantial evidence means that you build up a picture around the events, and having built up that picture, it enables you to decide what happened within the picture, what happened within the room. It's circumstantial evidence. And when sitting in a criminal court, as in the Crown Court, you would give a jury a very careful direction about circumstantial evidence and remind them that circumstantial evidence can in fact be extremely compelling evidence, like the man with a knife in his back and how that occurred. This case also deals with ABE interviews, as you'll see at the bottom. It is, of course, important to follow ABE guidance, and where it has not been followed, it's important for the advocates to identify the breaches of good practice, and then a further step has to be taken. And that further step is to ask, what is the consequence of the failure to follow guidance? You have to ask also, to what extent does it render the contents of the ABE unreliable? And that evidence then has to be put into the overview of the totality of the case. Of course, it's for the judge at first instance to evaluate the quality of the ABE interview. And if a judge does so, an appeal is unlikely to be successful. And you'll see what happened in this case in the italicized part. But I find very often you hear all sorts of things said about various questions that were asked within the ABE, but it's so important to take matters further. If you are going to criticize an ABE, not just identify where it went wrong, but continue to then to make submissions as to the effect that you suggest arises from the failure to follow the guidance. So please don't just leave it on picking holes in the ABE. You then have to take that further step. Thanks. We're going to now look at the use of research material in the case number 4 on the table. I wonder, it's probably helpful if we go on to the next slide, please, Isabel. Thank you. The trial process has to be an open process in which everyone can engage. And if a judge starts carrying out research of his or her own and takes that into account, that open nature of the trial process is traversed. It is, of course, wrong for a judge to do his or her own research. That, I think, is obvious. Research papers get produced frequently in, for instance, head injury cases. And there's nothing in this case that says, this Court of Appeal decision, that says you should not have research material before the court. But where research material is before the court, you have to recollect as the judge that it hasn't been tested in court, save to the extent that an expert may refer to it and comment upon it. The next point that you have to ensure is that the judge has got a full range of research material. How many times have people produced research material, for instance, that a subdural hemorrhage could occur from a drop of 18 inches onto a concrete floor? Well, there is research material, I know, to that effect. But there's a lot more research material as well, and you have to be extremely careful before making decisions that are effective by research material, unless you are sure that you have the full gamut of it before you. So if you get this in a case, can I suggest you do need to make sure that the research material is in its correct overall context. Also in relation to research material, do the facts of the case mean that the research material is relevant? Sometimes I will get a lever arch file of research material handed in and be expected to wade through it. A lot of it, I have to say, it is often just not relevant and is unhelpful because it clouds the issue and detracts from the focus of some from what the experts are actually saying in the case. And I think finally on this point, it's worth recollecting that of course, facts of the case will always trump opinion, particularly research opinion. So you're not going to find an answer to a case, save perhaps exceptionally within research material. It's to the facts of the case and the evidence that is produced within it that the primary focus has to be directed. The next case is a decision of Mr. Justice Kean. I think it's useful because it's a reminder of how family cases should interplay with criminal cases when the two are running in parallel. This can go horribly wrong. I had a fact-finding case where there were 5 experts in the family case. Unbeknown to us, the criminal case instructed 5 other experts, so there were then 10 experts. There were shades of differences between what they said. Then another expert got instructed in the criminal case and another one in the family. And we ended up with 13 experts. And so really this case is giving guidance about how to deal with the problems that can otherwise occur. And once a case has gone wrong in this respect, it is extremely difficult to get it back. So if you do get into a case where there are parallel proceedings, can I respectfully invite you to consider this case carefully? And of course, you will consider the protocol that's referred to in the italicized extract, the disclosure of information between family and criminal agencies and jurisdictions of 2024, the new protocol that's replaced the 2013 one. One of the things I think we do not do enough, with respect, is hold joint directions hearings. I've been involved in a few of those. They occur at an early stage of the procedure in both crime and family. The cases I've done, I've gone to the Crown Court and sat with the Crown Court judge with the advocates from both sets of proceedings. And the progress that has been made has been phenomenal. They are difficult to arrange, but if you are in the position where there are parallel proceedings, do please think about whether it would be beneficial at an early stage to have that sort of hearing. I'm a great fan of them and have found that they really do work. I'm now going to move on to the next case, which is an example of a fact-finding hearing that I'm afraid went wrong for 5 reasons that are set out there. The judge had given insufficient weight to another accidental injury. So you've got an accidental injury. You have to think, what is the relevance of that in my analysis of the suggestion that other injuries have been caused non-accidentally? Secondly, the judge had had evaluated the evidence in compartments instead of as a whole. Now, I had one of the cases that stresses the importance of avoidance of compartmentalization of evidence, called RE-T, was one where I got taken to the cleaners by Lord Justice Baker when he was at the bar. Foolishly, I offered to go first in the Court of Appeal in response to Jonathan Baker, QC as he then was, and I had absolutely nothing to say that could prevent the appeal being allowed, because the judge had compartmentalized the evidence. He'd looked at the medical evidence separately from the factual evidence and hadn't married the whole case together in an overview. And I'm afraid that's what happened in this case. The evidence had been compartmentalized. The judge had placed an excessive weight on the evidence regarding pain response of the child. that would have been expected. So the Court of Appeal disagreed with that. Judge placed too much reliance on research evidence, the point we've just touched. And finally, didn't conduct the overview. When I'm doing a fact-finding hearing, I quite genuinely, in almost all cases, reach the end of the evidence speeches and do not know what it is that I'm ultimately going to decide. I need, and it may be this is my own failing, I need to go away and think about it and put all the pieces together that I've heard. And only when you've done that and stood back from it, can you then decide what has happened in order to make reliable findings. And it is important to maintain an overview. If you don't do that, you end up making inconsistent findings. And that is one of the big flaws in fact-finding cases. Could we move to the next slide, please? Okay, thank you. So the next case concerns pool of perpetrator findings, which we've covered, but also to lies, how you approach lies. Now, we all know about the Lucas direction. I think when you have an allegation that a person has lied in a fact-finding case, it is very important to take the disciplined approach that this case urges upon everybody. So if it said that someone's lied, I think you need to ask yourselves these things. First, what exactly was said that is said to amount to a lie? Secondly, is it a lie? You have to recollect story creep, memory failure. You think of all the research about memory. Hillary Clinton saying that she landed under sniper fire in Bosnia when she didn't. It was just wrong. She was confusing events, and you can see that on YouTube. You have to recollect that once memory is fixed, it doesn't budge. So two people who see the same thing may well not report the same account of the events. It's not that they are lying, it's just that they are mistaken. The third thing is you have to ask yourself, why was the lie told? There may be many reasons why a lie is told that don't mean that the person is responsible for the alleged event or the alleged injury. The next thing is the lie relevant? The fifth thing, how does it fit in within the overall canvas of the case? And finally, is it relevant to demonstrate guilt or responsibility for an injury, or is it merely part of the overall credibility of a witness on which you may have any number of other evidential packages to help you? So just because someone has lied, it doesn't end there. And I've suggested 6 steps that need to be taken into account, which is a bit of an embellishment on the Lucas approach. The next case, Re W, concerns fact-finding cases. In the case, the Court of Appeal decided the judge's conclusion had not been shown to be wrong or contrary to the evidence, and it was the judge's function to consider the wider canvas of evidence. The court was satisfied that the judge's conclusion and reasoning are amply sourced and supported within the commendably detailed and well-referenced judgment, and so the appeal was dismissed. This is a case in which there were 18 grounds of appeal. Now, if you can't say it by midnight, it's not worth saying, I used to be told. If you have to say it in 18 grounds of appeal, it probably means your appeal is pretty useless. You just don't help by trying to swamp a notice of appeal in that way. It is difficult to appeal fact-finding hearings. And if you are defending an appeal in one, do look at this, because it gives the reasons why an appeal court should be slow to interfere with a fact-finding decision. An appeal is not a rehearing, and people forget that. if you're going to appeal a fact-finding hearing, you've got to show that the judge was wrong, not just that another court might have reached a different decision. So if you're in this arena of fact-finding appeals, can I urge you to consider that as well? The next case is case number 9, which is the General Dental Council. Really difficult issues arise where a family court has made findings here of domestic abuse against the dental technician, and other bodies need to see those findings to decide what to do. It can arise, for instance, in disciplinary proceedings, children's sports activities, schools, fitness to practice proceedings, and the like. So this case is not just about transparency. That's a separate issue. This is about what should happen when there's an application by a tribunal or another body for disclosure of a conclusion in family proceedings. And what Mrs. Justice Knowles said is that in considering what was required before deciding whether to order disclosure, it remains important that barriers are not erected between the family court and fitness to practice procedures created by statute. Furthermore, it continues to be desirable for the various agencies concerned with the welfare of children to cooperate with each other, including not only social workers, but also allied medical and healthcare professionals such as doctors and dentists. There is a balance to be performed, of course, between the Article 8 rights for respect for privacy of the dental technician in this case, and the wider responsibility to ensure the safety of others, and balancing those factors together. The court in this case decided that there should be disclosure, and it's a relief, I think, certainly to me, to know that that is how we approach it. Those of us with children, for instance, may have very strong views about that. I certainly do. So could we now look at the last case, which you'll be relieved to hear be the end of listening to me. Could we look at the next slide, please? And this is the case of J.M. Bath and North East Somerset Council and others. This is about deprivation of liberty, which I've tacked on to the end of this because it is recent and it is so important. In order for a thing to amount to a deprivation of liberty, there are three essential elements, and I'm grateful to Mark who prepared this summary. There's the objective element of confinement in a particular restricted space. So is the child confined? The second element, which is there's been no valid consent to the confinement. And the third is that the deprivation is imputable to the state. Now, I sit in the DOLS list for about a week every month at the moment, and we apply that analysis in every case that I do, or we do. It's the cornerstone of what we're doing because it arises under Article 5 of the Convention. And although this might seem like a complicated case, I don't think it is. I think it's really quite simple. Article 5 does what it says on the tin. So a person may not be deprived of his liberty by the state, save in prescribed circumstances that are then set out in Article 5. And the decision of the Court of Appeal is that where a local authority has parental responsibility for a child, it is acting in the state's capacity. So the third element of the three factors that must be in existence to create deprivation of liberty is made out. Any deprivation of liberty is imputable to the state because it's imputable to the local authority as a state body. And what Article 5 says is quite simple. That is not permissible, save following a due process of law. And I'm afraid the decision of Mrs. Justice Leven at first instance just drove straight through that. And so the Court of Appeal said that's not permissible. One of the points that was left open by them is whether their decision, however, related to attempts to deprive young people of their liberty in a domestic setting. Well, those of us with teenage children may have had experience of you're not going out tonight, and if you attempt to go out, I'll lock the door, or even greater degrees of confinement than that. That's not imputable to the state. Although the Court of Appeal leaves that open, I think there is a marked distinction between the parental responsibility exercised by a state body such as a local authority under Section 33 of the Children Act 1989 and other aspects where any suggested confinement of a young person is being exercised not by the state, but by someone else with parental responsibility, such as a parent or a special guardian. So specifically, this does not apply to other circumstances. But to those of us who work in this field, as I do, I can say that the Court of Appeal decision was an enormous relief. And it was also one that I have to say we anticipated. And certainly, in my instance, the decisions of Mr. Justice Kean and of Sir James Mumby that were different to the decision of Mrs. Justice Leven were being applied rather than Mrs. Justice Leven's decision at first instance. So this was just a wrong decision, I'm afraid, and thankfully has been put right. Well, that's enough from me. I've probably spoken for too long anyway. So, Mark, over to you.
Thank you very much indeed, Stephen. Isabel, could I ask you to move the thank you very much indeed to the next screen. Case number 11, and following on from what Stephen has just said to an extent, this is another decision which involves effectively, and I know we've headed it, revised guidance on intermediaries in family proceedings. It's not really revised guidance. It's the court having to deal with a decision of Mrs. Justice Leven and a later one of Williams J. in fairness. Mrs. Justice Leven in the West Northamptonshire case, which many of you will no doubt have read, because this is an issue which comes up for us in many of our cases. Shouldn't there be an intermediary? Does our client require one? What assistance do they require? So that decision in West Northamptonshire, which Mrs. Justice Leven dealt with, which was a case where mother's representative had in fact made a Part 25 application for I think in fact for a psychological assessment, but with the purpose of mother receiving assistance, which they had then withdrawn. But Mrs. Justice Leven went on to deal with it, despite the mother's representative having withdrawn that application on reflection, and gave the judgment, which had then been followed by the first instance judge in this case, but had led the court to effectively, as I've said, we've said revised guidance, to say, well, the guidance is the guidance. And I know Stephen's touched on this in some of the cases which he's already dealt with, which is the guidance is there and it's for us to apply it as family lawyers or judges dealing with the case, or the approach we might take, the applications we might make within proceedings themselves. And in this case, the court saying, well, the guidance is out there. Courts are well used to applying the test of necessity. That's the test in this case, or these cases for an intermediary. Is an intermediary required? Is it necessary? You don't need to add any gloss to that which is where Mrs. Justice Levin had with respect to her fallen into error, by adding caveats such as these will be the rare cases. It will be a rarity to have them. It must be exceptional, or any such other words, which in fact had been used. They're not necessary and or helpful. There is a test. It's set out very clearly within the rules, the evidence. The court in this judgment deals with where that evidence might come from. You might, for example, have a sort of communicant type assessment or other intermediary assessment. But the court says, well, we could have that from the social worker, the guardian in the case, indeed the vulnerable party and their representatives might be able to inform the court about that. It does say that we need to look at, are there participation directions that fall short of having an intermediary? It's not obviously automatic. But if you apply that test properly, then there are clearly going to be cases, and Riem was a case where it was a serious non-accidental injury case, where an intermediary was clearly going to be necessary, not only to assist the mother, as it was in this case, in court, but also, as per the direction that was then made on appeal, to assist her with legal conferences at court, but outside of the hearing itself. So that's a helpful decision, which really has got us back on track in terms of the guidance when you're looking at a case where you might have an intermediary. Last note on that case, the court does say that experienced representatives in court are able to deal with most things, but they're not able to deal in complicated cases with clients who do need the assistance of other people at court. So that's where you go to for the guidance if you're looking for an intermediary to assist your client. Moving on to the next case, case 12, this is Re T. Guidance on withholding material from a party. Don't know about you, this seems to be an application which is made more often than it was. Indeed, I'm currently dealing with just this issue in a long-running case, which is now post-fact find, but is awaiting its welfare stage. First point, Re T is a case which involved a private law dispute. These factors which are set out there, 1 to 6, which I'm going to come on to in a second, apply, of course, both to private law and public law scenarios. Re T was a case where the child involved, who's given a name in the judgment, Tom, dispute between the parents, which had gone on for some considerable time and was acrimonious, to say the least. Contact had been ordered, spend time with had been ordered for Tom to spend with his dad. Shortly after that order has been made, Tom had had some mental health problems, which involved him in visiting a mental health nurse. He didn't want what he had told the mental health nurse, or the information she provided in her reports, to be disclosed. The court dealt with that in a pretty short hearing, where the father and his representative had been excluded from the hearing, and a decision had been made that that material shouldn't be passed to the father. He in person had then appealed, and the appeal, as we can see here, had been allowed. The judge hadn't taken into account those 6 points. I won't spend time going through them. You can see them there on the screen, and you'll have them in your handouts. Those were set out by the court as long ago as 1995 in Re D, also in Re A, which is 2012 UKSC 60. had reiterated those in a slightly different context. But those are the factors you need to take into account. The court emphasising also that where it said that there's a risk of harm, that the evidence of that has to be set out particularly clearly. And that's only one of the factors the court's going to need to take into account. So it's a restatement really of guidance which has been there for, or 1995, what's that, 30 years, but helpful. As I say, my experience is we're having more of these cases than perhaps we once were. Go to that case of Bree, everything you need to know about how to approach and the criteria that's going to be applied, hopefully, is in that case. Case number 13, Re CB. Perhaps some of you will say, well, this is a bit of a niche point. Should extended family members be notified of the birth of a child arising from artificial insemination following a changed surrogacy plan? I see as our summary. It's really about notification when there's going to be an adoption, or that is the plan, to wider family members. Worth reading, obviously, if you have a analogous situation, but because of the frankly exceptional factual background, which I'll just touch on. The mother of the child concerned had met with some of her friends who'd said to her, we'd love to have a child, but we've got our problems and we're just not able, through medical reasons, to have a child. She had, unbeknownst to them, decided that she would help them. So she'd gone to a clinic where she'd been artificially inseminated. She'd become pregnant. She'd then gone back to the friends, explaining what she'd done. They indicated to her that they were no longer interested in having a family. Her own husband, she's in a partnership with a husband, she'd had 2 children, didn't find out about this until a few weeks before the birth, when he'd opened some correspondence that had come to the property. The mother was very clear that she didn't want a third child, and effectively was giving up the child for adoption. When the proceedings started, the mother couldn't remember, this was her case, she was not able to remember the clinic she'd gone to or the name of her friends. Indeed, the judge in the judgment, perhaps unsurprisingly, gives himself a Lucas direction about that information. Anyway, as you'll gather from that short update, a pretty exceptional set of circumstances. The husband, who's not the father, obviously, of the child, accepted what his wife had to say about that. He didn't want any involvement, and the judge had to balance whether members of mother's extended family should be provided with any information. I believe she had a brother who was living some distance away, who had family, etc., etc. So the judge had to balance Article 8 rights of mother, husband, and her own 2 children. Mother indicating, perhaps unsurprisingly, that it would cause very significant difficulties for the family, but both the nuclear family and the wider family of this being disclosed effectively, balancing that against the rights of any extended maternal family, and came to the conclusion that it wasn't appropriate to inform them. But useful, as I say. I think you're probably unlikely to have a case with those facts ever again, but who knows. But if you're looking for situations where these aren't entirely uncommon, where a mother doesn't want family members to have information or to be notified, and does, perhaps sadly, want to give a child up effectively, then that's the case to go to. The next case, 14, which is another, it's a notification case, but under very different circumstances. This was a case where mother, towards the very beginning of proceedings, was not wanting notification to be provided to the father. The background was an honour-based violence fear, which on the evidence, Judge Samuels KC, who was sitting as a Deputy High Court judge, was able to find on the facts. An application made by the mother in those circumstances that there should be no notification of the father nor his wider family. Now, the judge was able to apply, and obviously in a fact-specific way, the criteria in Re A, and we've got the reference there at the beginning of the note. Those factors are, one, whether the father has PR, two, the Article 8 rights of father in those circumstances. So, for example, if you'd had a father who does have PR, then not notifying him you'd need some, that's a much higher bar to cross. Three, the substance of the relationship between mother and father. So are we sort of one night stand territory, or have they been together for a particular period of time? Four, the likelihood of a familial placement. Sorry, that was four, wasn't it? But likelihood of familial placement. Five, the physical and psychological effects or impacts on the mother of the notification. Clearly was an important factor in this case. Six, the cultural factors. Seven, balancing harm. Eight, the impact of any delay. Nine, any other relevant factors. So a restatement of those principles, as opposed to the circumstances which were, as I've indicated, you may well agree, pretty unusual in the CB case. Cases we have where the mother doesn't want to notify the father because of fears of violence are sadly not uncommon. I say sadly in terms of mothers who fear serious domestic violence rather than having to make the application, of course. So that is something which comes up with some regularity within that decision, which sets out, I think, in a helpful way, not only the criteria in Re A, but Judge Samuels in that case was having to deal with a case which wasn't straightforward. So you can see there within that note, and if you've got a particular case, I'd say read the case itself, how one balances those various factors in what aren't always straightforward cases. Isabel, can we go to the next slide, please? Thank you very much indeed. Case 15. Fresh evidence on appeal. I think many of you will be aware of the Ladd and Marshall principles. That, I think, Ladd and Marshall is a case from the 1950s or the 60s. It's been around a very long time anyway. Which is, if you've got evidence you want to introduce on appeal, then you need to show it wasn't available with due diligence at the first hearing, whether it's going to be important to the result and whether it's credible. Not found to be credible in this case, although the Ladder-Marshall test was given the gloss that you can see in the final paragraph of that of our note. In that case, it was a report which had been undertaken, or the father had gone to annex, but it wasn't a Part 25 instruction, and had got some evidence about him being on the autistic spectrum, material which hadn't been before the court taking the view that in fact the material wasn't terribly credible. Moving on quickly to 16, not allowing lengthy adjournments. Mrs. Justice Lieben, who seems to be in all the judgments which seem to seek to shortcut. That's not a critical comment, of course, because we're all aware of the overriding objective. Applied pretty rigorously in this case. Mother wasn't on the radar. There was an aunt in Switzerland. There'd been quite a lot of attempts to get what had been ordered as an assessment of the aunt up and running. Evidence at final hearing that was going to take a minimum of another 9 months. Perhaps in those circumstances, not difficult for Mr. Justice Lieber to say that is too long. And having looked at the case law, BS, the overriding objective, etc., etc., she pretty swiftly, over a few paragraphs at the end, came to that very conclusion. The last case in my section, apologies for going on too long, at number 17, Berg and another, quickly. Transparency, we're all aware of the, well, we've become aware, the Transparency Project and all the invaluable work that Lucy Reed, KC and others have done, that we've got far more focus on that through the pilot and through the current guidance and rules on opening the family courts up. I know there are different views about it. I'm very much an advocate. Whatever one's own feelings, that's the situation. This was a doll's case. In fact, Sancha Berg is the journalist with the BBC. Effectively, the child concerned, Miss C, she wanted to effectively tell her story. And part of that story, of course, would be the fact that she was subject to proceedings, including Dole's proceedings, in a impeccable judgment, as usual, from Mr. Justice MacDonald, and at some considerable length. I'll warn you, if you have this issue before you to read it, comes to the conclusion, perhaps unsurprisingly, in a case where the person concerned wants the information out there, to use a shorthand, took the view that permission should be granted in all the circumstances. Jane, I do apologise. I'm handing over to you now, I know, with a relatively short period of time left, but that's my section dealt with. Thank you very much, everybody.
Thanks, Mark. Jane, over to you. Whoops. Jane, over to you.
Thank you. Can I just check that you can hear me, because I'm having some lag on my internet?
Yes.
Yeah, nice and clear.
Thank you.
Thank you.
Perfect. It's obviously just not very good for me, so that's fine. Okay, case number 18 on the list, which is H&J placement orders. And this case was an unsuccessful appeal against a placement order regarding the youngest 2 children of a sibling group of 5. The appeal court recognised that whilst there was case law in which there was a need to preserve the sibling relationships, it remained that the children, the older 3 children, were going to be in long-term foster care as opposed to being placed for adoption. And there was no general rule in respect of that. But it was held that the trial judge had completed a careful and thorough analysis of the options available to the children in reaching the decision that long-term foster care was not in the youngest two children's best interests. And you will see there that the judgment reminds practitioners of when parental consent may be dispensed with for the purpose of making placement orders. Case number 19, Re J. This was a case where the care order was made with a plan of adoption, although no placement application had actually been issued by the local authority. There were 5 siblings, and the plan was to place the youngest of the children for adoption. But at the time of the final hearing, the local authority hadn't actually issued the placement application, but still sought a final care order with a plan of adoption. But of course, this would have meant that it was without the approval of the agency decision maker for the local authority. The principal ground of appeal related to the judge making the final care order on the basis of a plan for adoption without actually considering the placement application, which would have brought with it consideration, of course, of the welfare checklist in the Adoption and Children Act 2002. And Lord Justice Baker gave the lead judgment where the appeal was upheld, and it was found that the trial judge was wrong to make the final care order in circumstances where there was an incomplete care plan to underpin the final order that had been made. And the judge had made a linear rather than a holistic assessment of the welfare options without properly addressing the heightened test, of course, for adoption. Next one is case number 20, Rien. And this case concerned 3 children by 3 different fathers, and all of the parents were foreign nationals. At the conclusion of the care proceedings, the judge decided that the middle child should be placed with his father in Italy, and this was contrary to the local authority's plan, which had been supported by the children's guardian. And you'll see from the note that will be provided that there are 3 points arising from this case, which are the requirement of a welfare assessment at the conclusion of the proceedings, and that has to be a balancing exercise. There is no presumption in favour of a natural parent as the welfare option for a child, reiterating what was said in Re H, and the guidance provided by Black LJ, as she then was in Re V, as to how to work with overseas authorities in securing cooperation and assessment in children cases was restated. Next case is Re AZ, and this is another appearance by Mrs. Justice Leven. And following a fact-finding hearing where Mrs. Justice Leven had made serious findings that the father had sexually abused his daughter between the ages of 10 and 16 years, she expressed preliminary views which were adverse to the proposal relating to the local authority's plan for the father to have such limited contact that it led to a recusal application both by the local authority and supported by the children's guardian. There is consideration of the authorities on bias and recusal, so it is an interesting case to read. Ultimately, Mrs. Justice Leven didn't recuse herself. She determined that she had not effectively prejudged the outcome of the welfare hearing, and then at the subsequent final hearing, which was of course her second judgment, she departed from her previous preliminary view that mother could manage the father's return to the family home safely. I'm just conscious, how are we doing for time?
So in about we're okay.
Okay, I'll keep going for a bit longer. Okay, Riem. which is number 22. This was where the judge at first instance rejected the application for a placement order in relation to a 4-year-old because it was based upon an erroneous belief that the current foster carer was going to continue to provide long-term care for the child. The Court of Appeal had held that once the judge had rejected the option of the mother caring for the child, he was required to evaluate the pros and cons of long-term fostering versus adoption in a balanced and holistic fashion. The judge's analysis was found to be linear and inadequate, and the Court of Appeal therefore repeated the caution of applying the test of nothing else will do. Next, we have the case of London Borough of Enfield versus RE, SW, E and TD. And this case was in relation to the welfare of a little girl who was 2 years and 4 months at the time of the final hearing. The local authority's final care plan, which had been supported by the guardian, was for the little girl to be placed with her paternal aunt in Ghana under a special guardianship order. And the court concluded that threshold was crossed and that neither parent was in a position to care for the little girl. The matter was complicated by the fact that the little girl had a diagnosis of sickle cell anemia and had had several hospital admissions. And at the time of the final hearing, she was actually having 4 weekly blood transfusions under the care of Great Ormond Street Hospital. Within the proceedings, medical evidence was obtained, which included a transcript of a meeting held between the little girl's treating consultant, paediatrician, and a consultant physician in the sickle cell anemia unit in the paternal aunt's location, and a 2-month transition plan had been provided to enable the little girl to have the treatment she required before leaving for Ghana. And the court carefully considered whether it was appropriate to make an SGO in these circumstances, because of course we have very clear guidance around untested special guardianship situations. But the court concluded that this was appropriate and justified in these circumstances. And of course, this is another one from Mr. Justice MacDonald, where he had carefully considered the issue of delay, and ultimately he concluded that the order should be made.
Okay, I think we should. I think, shall we, or we not to end there? Is that okay? Because it's 5:56. The case that you were touching on is, I think, really interesting, is it not? Because there, the special guardianship order was made, even though the child had not lived with the proposed special guardians time. So it demonstrates the exception to the usual position where the court will want to see the relationship between the child and the special guardians before making the special guardianship order. And that, in fact, is also reflected in the next case, isn't it, by Mr. Justice Poole, where the aunt and uncle lived in the UAE. So thank you very much indeed to everyone who has attended today. It's a really good audience. Thanks to LexisNexis. The next one is on the 19th of June. I'm really grateful to Mark and Jane for participating in this and presenting. These things take an awful lot of preparation, believe it or not, particularly when you're summarising a lot of previous decisions. So I'm very grateful to them. Do please join us on the 19th of June, when we'll be looking at risk assessment, adoption, and other issues that have been reported in cases, public law cases, then. So thank you, and that brings this to an end.